26th Zoning Board of Adjustment hearing. For the roll call, I can see that we're all here. Gary Brandt on that side, Doug Popham, I'm Jerry Capone, Linda Kaufman, and Lou Katz. So we have not just a quorum, we have a full complement of our members here today. Is everyone here for the first case? The first case we're going to do is 240 Rehoboth Avenue. Mr. Hutt, everybody's here for your case? Yes, sir. Tom? Yes. We're ready to go with that case. And would you announce, please, the status of the postings and mailings in this case?
The agenda for the August 26th Board of Adjustment regular meeting was City Hall and the City Portal on August 19th. The notice of the agenda was sent out from the City Portal on August 19th. The public notice for case number 0719-05 for the property located at 240 Rehoboth Avenue, and case number 0719-06 for the property located at 2 Rehoboth Avenue was posted at City Hall and on the City Portal on August 1st. Both public notices were published in the Cape Gazette on August 6th and August 9th, Coast Press on August 14th, and Delaware State News on August 8th and August 9th. Notification specific to each property was mailed out to property owner addresses identified by Sussex County within 200 feet of the subject property. Signage was posted on the property.
Thank you. It sounds like notices were sent out and in accordance with the law, so I think we're prepared to go forward here. Anna, is there any general correspondence for the board? No.
Only specific cases.
Okay. And now I'd like to move to approval of the minutes of the last meeting. Has everyone had a chance to review the minutes from our last meeting?
Yes.
The July meeting.
From the July meeting?
Yeah.
Is there a motion to approve the minutes?
I'll make a motion.
I'll
Is there a
second it.
All in favor, say aye.
Aye.
Aye. Okay, that the motion carries. I'm going to sign the minutes. And if you could pass these down towards the clerk, please. Is there any old business? No old business. So we're prepared to address the new business tonight. And tonight, we have two cases for our consideration. The first case we will hear concerns 240 Rehoboth Avenue. In this particular case, the applicant has appealed the decision of the building inspector, which held that the construction of an outdoor deck and stairway triggers a requirement for an off-street parking place. If we reverse the building inspector's decision by concluding that he made an error in interpreting the code, the case is over and the applicant will not need to provide an off-street parking space. But if we affirm the decision of the building inspector, the case is not over. We will then consider whether to grant the applicant an area variance, which would relieve them of the requirement to provide an off-street parking space. Under Delaware law, the legal standards to be used in evaluating a request for an area variance such as this are found in the Quick Check case. Quick Check versus Board, it's called Board of Adjustment versus Quick Check Realty. It's a Delaware Supreme Court case. And I'm going to review with you the Quick Check standards. According to the language of that case, the standard to be applied to area variances considers whether literal interpretation of the zoning regulation results in exceptional practical difficulties of ownership. This standard is satisfied only when the difficulties alleged by the owner are practical rather than theoretical and exceptional rather than routine. In order to determine whether exceptional practical difficulties exist, the board must weigh the four following factors, which we call the Quick Check factors. Factor one, the nature of the zone where the property lies. Number two, the character and uses of the immediate vicinity. Number three, whether removal of the restriction on the applicant's property would seriously affect the neighboring properties and their uses. And number 4, whether failure to remove the restriction would create unnecessary hardship or exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements to the property. Ladies and gentlemen, in general, the board is not permitted to consider factors other than those 4 factors. But I suspect that most of you are here tonight for our second case, which is an application seeking 7 variances to permit construction of a hotel at the corner of Rehoboth Avenue and the boardwalk. 6 of the 7 variance requests are for area variances, which would be governed by the quick check standards I just read to you. But the other variance request seeks a variance from the requirements of Chapter 159 of the City Code, which concerns flood damage reduction. The standards for granting a variance under Chapter 159 are much more detailed and far-ranging than the quick check standards, to the extent it would take some time for me to recite them for you right now. But I will be discussing those standards with you when we start the hearing on that case. And for those of you who want to begin familiarizing yourselves with the Chapter 159 standards, the board has made 50 copies of the ordinance which sets out those standards, and you can find copies, looks like this. They're on the back table outside this meeting room. Now, there are many people here tonight. We thank you all for coming and taking an interest in the work we do here. Those of you who wish to speak will be given the opportunity. There's a sign-up sheet outside in the back. If you plan on speaking, please sign that sheet and you will be called in order. Note that there are 2 sign-in sheets, 1 for each case, so pick the right case that you want to speak about. If you do speak, we ask that you address only the issues before the board. And by that, I mean the legal criteria for the variances which I previously discussed with you. We also ask you to refrain from making comments that have already been made by other speakers. Please note that we have a court reporter present. For her to do her job, it is important that she be able to hear what each speaker says. So keep your voices up. And please, no cross-conversation during the hearing. We ask that you observe a level of decorum that you would expect to find in a courtroom. And like in court, everyone who chooses to speak tonight will be required to give their testimony under oath. There's a Bible in front here. You'll be asked to swear on the Bible or affirm. Thank you for your attention to these remarks, and we are now ready to begin the hearing of our first case. I'm going to ask the parties to please come up and sit at the table directly in front of the board, please. So we know Mr. Molina and Mr. Mandalis. Could you please introduce yourselves for everybody tonight?
Certainly. Good evening. My name is David Hutt. I'm an attorney with the law firm of Morris James. This evening, I am representing the applicant in your first application, which is Jack Lingo Asset Management. And sitting to my left and your right is Nick Hammonds, one of the principals of that entity. And in the second row is Doug Motley, another principal of that entity.
Okay. I'd like to have the report of the building inspector at this time.
I suspect you don't want me to read the whole thing.
Good guess. But I would ask you to keep your voice up, okay?
Okay, I'll try. Today I'm under the weather, but I'll try to do my best.
All right.
This is essentially involves an expansion of the structure under 270-29, which specifically is for off-street parking. And while an individual, like they did in the past, expanded the first floor to the second floor, and it was less than 75%, that did not trigger the parking. What does trigger the parking is at the instant that you expand to the outside to make a walkway. Now, this walkway is for general for purposes of this discussion, it's not an emergency egress. It's just a general means of egress from the property. And the reason that comes about is because the fire marshal and the building inspector have two different perspectives, or based on the code, on how we allow buildings to continue to use, especially when they expand. In my review, it was under the building code, the uses continue to be the same. The occupancy load is less than what the code requires for having two exits, where they're at 44. The code says less than 49. And the travel distance from the furthest point of the building to those stairs has to be 75. Whereas the fire marshal says, hey, you could have 100 feet. You can travel 100 feet, plus your occupancy load, if I understand correctly, is at 100 as well, and you're only required to have one exit. Now, what the difference between the building code and the fire marshal is that the only way that they can comply with the fire marshal is that they will have to close an exit on the first floor, exiting from the first floor into the stairwell and then into the street. There has to be a wall there that's probably costs a couple $100 to close up and fire rated. And then the travel distance on the first floor is maintained. The travel distance on the second floor is maintained as well. Now, and that option was presented to the applicant. The applicant decided, no, I want to do another means of egress and go through the size of the property. That triggered the additional requirements for parking. I just want to say that in a nutshell.
Okay,
All right.
so that's your report.
Question.
So we have a question from Ms. Cochran.
Sure.
So Don, just to be clear, the fire marshal's saying one thing, you're saying another, but you're saying that one of the solutions was to close off that doorway.
That's correct, and that was a recommendation the fire marshal made to the applicant.
Okay.
And I met with the fire marshal because I used to do fire marshal work before, and I was wondering what's the difference, and we discussed it, and that's the salient point with this application, that first floor has to be closed off, at least for the fire marshal, but not for the city code.
But isn't there also, and I don't want to jump ahead for his presentation, but isn't there also a discussion as to whether the outside deck constitutes the gross floor area, and therefore whether it kicks in that provision for the needed parking?
Well, you have to look at, this is the other part of the debate, whether that deck, which is considered a structure under the definition of the building code.
274.4, right?
270-4, right. It's considered a structure, and then the issue is, do the railings constitute walls? According to, in my application, you're defining a space, you're enclosing it, and that basically constitute additional square footage.
Okay.
Okay.
Any other questions for the building?
I do have a question. Under, Section 4 of your report, 4C, the last paragraph, are we talking about, it says, under Delaware Fire Code, the interior stairs to the second level, if dedicated to the second floor and not accessible by the first floor, are adequate to satisfy the code? Is that the point you're trying to make?
4C, specific comment for an egress.
Yeah, at the end of that.
Let's
building, it's not
not
a
talk,
requirement.
Dom, you're going to have to keep your voice up, please.
Yes, it is. That's what I'm
Okay, thank
referring
you.
to. Okay.
And I guess the question before the presentation, looking at the blueprint of the deck on the roof structure, is if that deck size was changed, would that fall under the 75% of the change?
Well, the question is, if that deck was changed, even an inch will trigger the parking requirement. So the moment you add structure or enlarge the
Okay.
building,
It's 75% within.
Within that, okay, thank you.
So what is the size of the deck?
Roughly under 400 square feet if you don't include the stairs.
So this is more than a fire escape?
Well, fire escape is a whole different
I
terminology.
understand, but
It's not a
it's
fire
more
escape.
it's more than a means of egress?
Right. It's just an egress, general egress. I don't go to label it an emergency egress.
Okay. Let me ask you this. Is there any prohibition against, or any concern that we should have that if this is permitted, that there's no need for a interior stairway?
That is correct.
So correct, in other words, that if this exterior stairway is permitted,
Right.
then there's no need for an interior stairway?
That's correct.
Let me preface that. I mean, I think there would probably, that interior stairwell, as I understand it, will remain. The change that's happening here is my understanding is that they are adding additional real estate offices to the first floor, to the second floor. They want the second floor employees to be able to use that stairwell to enter the first floor where the main office area is. The fire marshal has said you need a dedicated egress from the second floor. And you can close off that first floor portion of that stairwell, and that'll be your dedicated egress. But that doesn't seem to work from a business perspective where you want agents to be able to go up and down
Without
from
having to
first
go
floor to
outside.
second floor in the interior space. So it wouldn't be necessary to have that interior stairwell, but a first floor employee would need to go outside,
Gotcha.
down the stairs, then back in to access the first floor.
And so by virtue of them adding that, that triggers the parking and therefore the one
Right.
spaces.
Well, it triggers the parking, but it also trigger in the future enclosures. Once you grant the variance, that area can be enclosed because this is part of the structure. It becomes,
Wouldn't you need a wall to enclose it?
yes, you do, but the square footage is already calculated if you approve it.
What's the height of the railings?
I believe 42.
Is there a roof over this?
No, not right now.
But there could be.
There could be
There could be with a permit.
with the permit, yes.
If there was a roof sought, let me back up. If the variance, if we decided that they were right, if they wanted to enclose this, put a roof over it, would that increase the square footage?
Well, it doesn't, because as long as they don't exceed the height, it won't, the height limitations, they won't exceed it, but it's already factored into the FAR, because we're dealing with a commercial community, so it's building plus structure. And they're well below the FAR for that district as well, for that C1 district, that location.
So, I mean, this comes down to, is it a structure, isn't a structure? If it's a structure, even by increasing it by 1 foot, it then requires that extra parking space.
That's correct. I have no doubt that it's a structure.
Okay. And the definition of a structure, I guess, comes down to, you know, do the railings, and historically, when you've had decks on, second floor decks on other people's homes, things like that, you've counted that as part of the structure?
We count those as well, yes.
Any other questions for the building inspector? Mr. Hutt, it's your turn.
Excuse me, Chairman,
Yeah,
use the microphone.
I'm sorry, and I'm the guy who, there's a certain irony there, all right. Mr. Hutt, your turn.
Good afternoon again, or good evening. As you know, probably more often than not, Board of Adjustments see variance applications. But of course, the first part of this application, as it was introduced by Mr. Capone, is not a variance application, but is an appeal of a building inspector's decision. Pursuant to Section 270-71 of your code, the board has jurisdiction to hear appeals from any person aggrieved by any decision of the building inspector. One thing I will always like to begin with whenever I present an appeal of a building inspector's decision is to note that this is not a personal attack of any sort on Mr. Molina or his office. This is just part of the process of land use. Certainly my office, and I know my clients' offices work with Mr. Molina on a regular basis, so this is not intended to be directed at Mr. Molina personally or at his office. Mr. Molina reviewed some of the history with you, and some of it was included within the building official's report, which I know is part of the record. I wanted to go through a few more details about the history of the journey that brings us here this evening. Last year, and I'm going to refer to my client, Jack Lingo Asset Management, as just Lingo for the sake of using less words throughout the evening. But Lingo decided to convert the upstairs of the office at 240. There's actually two street addresses for this one tax parcel, 240 and 242 Rehoboth Avenue. They decided to change the use of the upstairs from a two-bedroom unit to additional office space, as Mr. Mandalis mentioned a moment ago. Of course, this would bring the whole use of the building into one single use and certainly conforms with the C1 zoning classification and zoning district in which the property lies. Plans were submitted to the city, and those plans included a deck that measures approximately 25 feet by 25 feet on the top of the first floor or as you walk out of the second floor. Those plans were approved by the city, and an email was sent on November 16th to Lingo advising them that the plans could be picked up upon payment of the applicable building permit fee. That set of plans was not picked up. Instead, it was decided at that time to forego that set of plans, and the next set of plans that was approved simply removed that deck. The second floor deck that had measured 25 by 25 with a set of stairs leading down the back of the building towards Wilmington Avenue was simply removed. And the early part of this year, I think it's January 2nd, that building permit was obtained for a building that did not have any decks at all, whether it was the 25-foot by 25-foot or what I'll call the emergency exit walkway and stairs. During construction, and as that process moved forward, the State Fire Marshal's office did indicate that because of that doorway on the first floor, that a second means of egress direct from the second floor would be needed, which is why a set of plans was submitted to the city showing not the 25-foot by 25-foot deck that was originally proposed, but simply a walkway leading from a door on the second floor to a set of stairs that takes you from the second floor down to ground level or street level. When applying for that building permit, the city informed Lingo that that would not be approved and that an additional parking place would be required because it was an addition of gross floor area to the building. As you can imagine, that was a bit of a surprise to Lingo, as they had previously obtained a permit or had the ability to obtain a permit for a deck of substantially more size and more use for that. And I think it was also surprising because whether the deck is 25 feet by 25 feet, whether the deck is simply an emergency walkway leading to a set of stairs to get to the street in the event of emergency, in either event, it doesn't increase the occupancy load of the building. There's no employee there that is going to be stationed outside of that desk. It's not a storage area, of course, so it doesn't change anything about the building per se as to how it's going to be able to be used in the professional office context. Upon receiving the decision of the building official, it was of course questioned as to why or how a deck of this nature counts towards gross floor area. And of course, this evening, we're here on an appeal of that decision of the building inspector. The Delaware law indicates that when a Board of Adjustment like this is making a determination of this nature, that you're sitting in what's called a quasi-judicial capacity. This afternoon, in that capacity, you're going to be asked to interpret the meaning of essentially 5 words within the definition section of the Rehoboth Beach Code. And those 5 words are the exterior face of the exterior walls. And that phrase comes straight from the definition of gross floor area, which in your code is floor area, comma, gross. And that's in section 270-4 of the code. Applying those words to this situation, the question becomes, is a railing the exterior face of an exterior wall? Lingo's position is that the fundamental mistake in the building inspector's position is that it attempts to go beyond the plain meaning of those words and seeks to add to that definition. We heard a moment ago that a railing would be considered, starts to include areas within it, within the gross floor area calculation because it defines the space and then closes it. But that's not the definition of gross floor area that you find in the code. And whether a person is a legislator, an attorney, a judge, or a board sitting in a quasi-judicial capacity, such as yourselves, there are basic principles of statutory construction that apply when interpreting the language of a code or a provision like you're being asked to do this afternoon. First of all, the goal is to give effect to the intent of the legislators as expressed in the statute. And that is, in fact, just the plain meaning of those words, the exterior face of the exterior walls. If the first part of your consideration then is a determination as to whether or not that language is ambiguous. If it is not ambiguous, then the plain meaning of those words controls the outcome of your decision. If it is ambiguous, then the law says that the code must be construed as a whole in such a manner that it gives effect to all of the various provisions within the code and avoids what the law calls absurd results. Finally, if there are two reasonable interpretations of a code, the interpretation that favors the property owner is what controls to protect the free use of land. And again, those are all concepts that are well recognized in Delaware law and jurisprudence. There is a Delaware Supreme Court case from which I took most of those comments, the Chase Alexa case. I'm sure Mr. Townsend and Mr. Mandelis are familiar with that case. As I mentioned a moment ago, the very first level of analysis on a code provision such as this is whether or not the language that's within that code is ambiguous. It is Lingo's position that the words in question in this matter are not ambiguous. The plain meaning of the exterior face of the exterior walls is, in fact, the exterior walls of a building, not a railing that surrounds a building or surrounds a portion of a building, but is in fact the exterior walls of a building. In fact, this was the city's first interpretation of this section of the code when it indicated that a building permit could be picked up for a deck that was substantially greater in size than the one that was proposed more recently this spring. In short, instead of going beyond the plain meaning of those words, that's actually what the city has done. It's gone beyond the plain meaning of those words and seeks to impose things like enclosing an area, defining an area within the definition. But if the plain meaning is used, an area such as a deck or a balcony is not included within gross floor area. I certainly recognize that you've just heard the city's position and you have the city's position in a report. So for the sake of argument this evening, I will treat the city's position as if those words create an ambiguity. As you recall a moment ago, in that circumstance, the role of the reviewing body is to construe the statute as a whole in a way that gives effect to all of the provisions that are within the code, and again, seeks to avoid what the law refers to as absurd results. In this case, the ambiguity may be found in the term deck. It may be found in the term exterior face. It may be found in the term exterior wall, because while component parts of each of those words and terms that I just used have references in the code, none of those three words or terms are expressly defined with the statutory or code provision within the Chapter 270 of the zoning code. The city's position is that the correct interpretation of those three terms is that a deck is a form of a structure, and a building is a structure with walls. A railing is a wall, thus it's an exterior wall. Of course, that's not necessarily true because there's no definition of an exterior wall. And that process of trying to connect all those things reminded me, as I was thinking of it, of a little bit of that song from our childhood that we all know about the toe bone being connected to the ankle bone, being connected to the knee bone, being connected to the hip bone, and trying to relate all those things together. Setting aside that circular logic, there's nothing in the Rehoboth Code to suggest that it was the intent of the city commissioners in adopting its definitions of gross floor areas over the years to have a railing count as an exterior wall. In fact, Lingo would argue that common sense and the result of such interpretations points to the opposite of that position. One of the things I wanted to do was begin, as I was thinking about this, I went online, and of course, today we all rely upon Google. So if you Google deck and look for a definition of deck off of Google, a definition from Wikipedia, and again, I'm going to set aside the nautical definition of deck, because obviously there's a whole context of definitions that all relate to nautical terms. But in architecture, a deck is a flat surface capable of supporting weight similar to a floor, but typically constructed outdoors, often elevated from the ground, and usually connected to a building. Again, I think that last phrase is important. It's connected to a building. Not content with that one definition, I saw that the next one was dictionary.com. And again, I'll set aside all the nautical uses of the word deck. But once you do that, it's an open, unroofed porch or platform extending from a house or other building. Again, it's an extension, it's something that extends from the house or a building. And that's one of the reasons why we argue that's the plain meaning of those terms in this context indicates that you don't have to get to the ambiguity. But assuming that you do get to the point where you think that there are two reasonable interpretations and that there is an ambiguity here, I think the next logical question that follows as part of the consideration of this is, if the railing becomes the exterior wall of the premises, what does the current exterior wall, the wall that supports the building, the wall that supports the roof, the wall that has the insulation in it, the wall that keeps weather from getting into the building, what do we call that wall? The city's argument would lead one to conclude that a building can have two exterior walls at the same place in the exterior. One might actually be an exterior wall, and the other is something else, such as a railing. Of course, that doesn't make sense, as buildings don't have multiple exterior walls. And in fact, that interpretation would run afoul of the city's enforcement of its own building code. The city has adopted the International Building Code. I think it's at the 2012 version of the building code. But if you look in Chapter 14 of the International Building Code, exterior walls is actually a whole chapter. There's defined terms that talk about exterior walls. And exterior walls provide the building with support. They support a roof. They provide a weather-resistant exterior barrier. They have an exterior wall envelope. They are insulated. All of the things that you would think of as you were thinking about a building and somebody said, what's the exterior wall of that house? The question, the baseline question of that, the person's not going to go to a railing. They're going to go to the wall that does all the things that the International Building Code, your building code, says an exterior wall accomplishes. And the result of this, again, one of the statutory keys is to not have a result that is what the law refers to as an absurd result, where you have two different exterior walls. And what the city's interpretation of this would mean is that you have the opportunity here to have an exterior wall of one fashion under your building code and a completely separate, different exterior wall under your zoning code. The other issues stem from that, but there is no, as we said at the outset, there is no bulk that is added to this building, or frankly any building, by the addition of a railing of this nature. And that's typically the concern that you see. But to summarize and bring this portion of the hearing, our presentation, to a conclusion, the meaning of those words, exterior face of the exterior walls, is not ambiguous. Its plain meaning is the external wall of a building that has the weatherproofing, the insulation, supports those structures. That is what the plain meaning of an exterior wall is in the code. Again, this is probably best highlighted by even the building inspector's report. If you look at page 3 of the building inspector's report, when referring to the proposed deck, it notes that a section of the proposed deck is to attach to the exterior wall. Again, it's difficult to describe a deck other than as an extension of, or the other terms that we saw in the dictionary definitions of those terms, where it's something that extends from a building, it's something that's connected to a building, and you connect things to the exterior walls of a building. That is the plain meaning of that. If the board finds that phrase is ambiguous, again, subject to two reasonable interpretations, then it should construe the code as a whole. And again, an exterior wall is something that's defined within your building code, and it does all of the things that you would think that an exterior wall would accomplish. And in that case, for consistency purposes, and so that no absurd results are wrought by assigning the same wall two different terms or definitions, the same result is reached. I guess, finally, it is important to remember, as I said earlier, that even assuming that there are two reasonable interpretations and that there is an ambiguity, the interpretation of that ambiguity runs in favor of a property owner to protect the free use of land. That concludes my presentation and comments. I'm happy to answer any questions that board members may have.
So I appreciate what you just went through describing, but as I understand it, and I think what you've described very eloquently about walls has more to do with the gross floor area, and that's the FAR. What's triggering the parking isn't the FAR, it's the structure. And so I don't think that the wall or the exterior wall or any of the definitions that you had really even comes into play. Because if you go through the code, 27029 describes that this article shall not apply to any existing structure. And so what's triggering the parking is the structure, not the fact that there's an exterior wall or a wall. And then if you go back to the definitions of structure, it's anything constructed or erected, including any part thereof or use which requires permanent location on the ground or attachment, and it goes through, includes balconies, decks, canopies. So I would argue that, as much as I appreciate the explanation you just went through with walls, that has really nothing to do with this particular case, because that's a FAR issue and a gross floor area, not what's triggering the parking. And isn't that what this is all coming down to, is what's triggering the parking, and it's a structure. And so, my connecting the dots is a deck is a structure, and the structure change is what triggers based on 27029.
I will say that has not been the city's position to date. The city's position to date is that it is the gross floor area that is being increased in size. And that is where we have to decide what the exterior face, or the board has to decide what the exterior face of the exterior walls is. And again, it's the definition of gross floor area is the sum of the gross horizontal areas of the several floors of a building measured from the exterior face of the exterior walls. It goes on from there, but the rest of it's not relevant to this afternoon's discussion. And so it's whether or not Mr. Molina was interpreting or is interpreting the code to mean that the gross floor area of the building that exists at 240 and 242 Rehoboth Avenue is being increased in size with this proposed deck. And again, the only way to get there is through those machinations that we just talked about of the wall, structure, deck, and trying to piece that together.
And then just one more question. Is this Lingo part of the whole Lingo complex? I mean, is it all one same entity? Lingo Realty, Lingo?
They are all separate entities.
Because I'm wondering, and I don't know the legal way that it works, but why 27035 wasn't considered, with the fact that, if there's parking within 700 feet owned by the same entity, they can use those?
That was discussed earlier in the development of the plan. There's parking with some of the buildings that they demolish on Christian Street and Scarborough. There was a discussion about it, very, very short discussion.
So my understanding, again, I don't know the ownership details, but wouldn't this whole thing be solved because they could just use one of those parking spaces?
If Lingo is the whole, if Lingo is the holding company representing all these management, then I believe it can be resolved.
Then why are we here?
You ask the client.
Because there are multiple entities involved. They typically involve similar and overlapping parties, but not necessarily all of the same parties. And of course, once you take a parking place from one location, it's not available at that location anymore. And the argument is that there's no additional parking place that's needed for this deck and emergency exit.
Well, I mean, knowing how precious parking spaces is, I can't imagine that Lingo's couldn't work out one space. I'm done with my questions, thanks.
Anybody else have questions?
Yeah, I have a question. So to the building, the city approved it when it was a 25 by 25 foot deck with no additional need for a parking space?
Well, I would say early in the submission, I was blindsided by this provision 27029, and I just counted there wasn't more than 75%, okay? And the reason for that is I'm relying on the building code, not the fire marshal, okay? So I looked at it, and I said, you're okay to go. I issued them a permit that they could do the interior renovations of the second floor. It appeared to be the same same occupancy. And then after they have withdrawn the deck and they came back again, I questioned on that, and I said, look, I think after further reviewing of this section, you are required to provide parking spaces.
Okay, thank you. And then you had the deck, and then you didn't have the deck, and now you're putting it back on. So somewhere in your process, you thought in the middle one, where you didn't have anything, that you could make this situation work. What changed your mind? Why can't you wall up that door down, I guess, on the first floor? You didn't speak to that at all.
That doesn't get into I certainly could, I'm happy to address that, but that gets into probably the variance discussion as opposed to what is the meaning of the 5 words that we discussed earlier. I mean, I'm happy to answer that. Actually, I was going to have Mr. Hammonds answer that question later in the presentation if it was necessary.
Okay, I'll wait for that then.
Any other questions on this subject? Okay, are there any members of the audience? There's one name who signed up to speak. Does that person wish to speak to this issue or the hardship issue if it comes up? This one. I recognize Tom Evans. Please come up. Please take the Bible and swear.
I won't do the Bible, but I'll swear.
Okay. Do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do. Tom Evans, 512 Newcastle Street. 2 things which were avoided or not spoken to. One is actually in Dom's report, but also is a section of the code, which is under 270-4 under definitions on decks, which clearly set, and I'm going to go down to the pertinent section, a section of the proposed deck is to attach to the exterior wall of the building, and the perimeter rails become the vertical extension, the vertical exterior surface wall. That's in the code. No one mentioned that, neither Dom nor Mr. Hutt. Secondarily, no one chose a legal document, a legal dictionary to look at the definition of wall. And it says under one of the definitions, erection of a stone, brick, or other material raised to some height and intended for the purpose of security or enclosure, both of which are a rail in some sense. Thanks.
Tom, I'm sorry, what section, on,
In Dom's report, it's section 270-4 according to Dom's report.
Could you slow that one more time? 270-4.
-4.
Thank you.
well, that's the definitions. I was trying to find where you were,
It's recorded in that section of Dom's report.
okay, thanks.
And you mentioned the definition of deck?
270-4.
If I may,
Page 3.
that's page 3. It's actually right after the section that I highlighted of his report. And that's not the definition that's found in the City of Rehoboth Beach Code. That's Mr. Molina's opinion about what he thinks. Again, as I said before, there's a lot of circular logic there that gets to that point, and that's not the exterior face of an exterior wall.
I don't see it either.
He was quoting the report. Could I ask Mr. Hutt a question?
Of course.
Mr. Hutt, you heard Mr. Molina say that...
Microphone.
Nah, I'm sorry. You heard Mr. Molina say that the area would be counted towards the gross floor area that's attributable to this deck, whether it's enclosed or unenclosed, or whether it has a roof or not. Would it be your position that should you be permitted to develop as you've asked and you're successful tonight, would it be your position that you could enclose that deck without increasing your gross floor area?
No, I think that if you were to enclose it and you were to put exterior walls, walls that support, walls that keep weather out, walls that are insulated, you make an exterior wall and then you enclose that then the owner of the property and the applicants, or whoever the applicant was at that point, would have to come in and they would have to do a gross floor area calculation. They'd have to do the floor area ratio calculation and any of the other calculations that are necessary at that point. Yes.
Thank you.
So, I'm sorry.
No, you can go ahead.
So I'm struggling a little bit, because if this isn't an exterior wall, what would you call it? It's the outside, the farthest outside part of the building. So if it's not an exterior wall, what would you call it?
It's a railing around a deck. It's not it doesn't make it an exterior wall.
All right.
May I follow up a little bit on Ms. Kaufman's comments? So she mentioned that part of the reason that the city's taken the position it's taken could be that structure, in addition to structure, counts as gross floor area. And I just wanted to point out that position is contained within Mr. Molina's report. It's also on page 3. There's one full paragraph, and the second full paragraph says, given that this building is located in a commercial district, compliance with the floor area ratio, FAR, of 2.0 can only be ascertained by counting the gross floor area of not only the building square footage, but the square footage of the deck, parentheses, structure. So he's indicating that structure matters in addition to gross floor area that you traditionally think of with the building structure itself. So that argument was contained in his report. Secondarily, I'd like to mention, speaking to the issue of statutory construction, there's a case called Friends of Paladin versus Newcastle County Board of Adjustment, and it tells us when a statute is ambiguous. And we've spent some time now talking about what is a wall, what is not a wall, what is a deck, what isn't, when is it gross floor area, when is it not. So it seems to me that there is some discussion to be had about what is the meaning of this statute. So that court said, a statute is ambiguous when it is reasonably susceptible to different conclusions or interpretations, which I think is the conversation we're having right now. It's reasonably susceptible to different conclusions or interpretations. Ambiguity also exists if a literal reading of the statute would lead to an unreasonable or absurd result not contemplated by the legislature. If a statute is ambiguous, it should be construed in a way that will promote its apparent purpose and harmonize it with other statutes. Such an interpretation would align the statute with the goal of statutory construction to give effect to legislative intent. So I think it's important that we do look for a moment at what was the legislative intent of these statutes. And all of these statutes dealing with FAR and floor area ratio, when they were revised several years ago, it was all about bulk within the city. It was all about more and more structure being built, and how do we control bulk. And FAR was one reason, or one mechanism to deal with it. You know, an absurd result, if we're trying to deal with bulk, wouldn't it be an absurd result if we had a very small structure with many cantilevered decks coming off that structure, clearly creating a lot of bulk, but not being addressed under those statutes that were specifically adopted to address bulk? And as to legislative intent, there's one portion of the code that does speak directly to what were the legislators, what were the commissioners thinking when they adopted these provisions. It's found in the residential code versus the commercial code in the residential districts. But in those districts, in fact, I'll bring it up. So in section 270-21B1A, and B is titled floor area ratio. Subsection A says, the first 250 square feet of an open porch shall be excluded from the gross floor area. So you get a credit for open front porches, not excluded or not included in gross floor area. So the first 250 square feet of an open front porch shall be excluded from the gross floor area, provided that such porch is on the street side of the building at the first floor level, roofed, one floor with no living space or deck above the porch, meets the definition of open porch in section 270-4, and is not heated or air conditioned. Then it goes on to say, any square footage in excess of 250 square feet shall be included in the gross floor area. So here there's a clear provision where it's an outside, it has to be outside in fact. You can't have walls on it. You can have, however, though, under the definition of an open porch, you can have a guardrail, you can have a railing, you can have insect meshing. So you can have something there that's creating or enclosing that space, but you can't enclose it entirely. And the commissioner said, we're going to give you a credit because we like open front porches, but let's just be clear. All of that space is to be counted as gross floor area. We're just giving you a credit in this instance because we like open front porches. You don't see it as much in the commercial district, and there's not a provision specifically addressing it in the commercial district, but that's generally because I think in the commercial district, you can build in most areas the entire lot. So it's not as common to have outdoor decks or open spaces like that. In the recent Agave application, I can tell you we applied the same definition that the deck they proposed was going to be counted toward gross floor area. But again, back to legislative intent, the only place that we find within the code that speaks directly to the legislative intent of outdoor spaces like that clearly expects that those spaces will be included in gross floor area.
And just one last comment as I go through this. Wall is defined as the vertical exterior surface of a building.
Right.
So, okay,
All right.
I'm ready.
Are there any other questions? Any other comments?
If
Right.
I may.
Yes, Mr. Hunt.
In response to what Mr. Mandalis just indicated, as he indicated, what he presented about open front porches is something that lies within the residential code. And tonight's appeal actually doesn't relate to FAR, it relates to gross floor area, which is a separate, it's the numerator in your floor area ratio calculator, but it is a completely separate term than floor area ratio. I think it's also important to note two things about that. First, that section applies to open front porch. That's actually an open porch is a defined term within your code. It doesn't say it applies to decks. It doesn't say it applies to balconies. It doesn't say it applies to any of things that are like that or of a nature of tonight's application. In addition, we don't need to worry about what the legislative intent was with respect to an open front porch. As Mr. Mandalis read it, the last sentence says, any square footage in excess of 250 square feet shall be included in the gross floor area. The code makers knew how to make it clear if they wanted something included in the gross floor area. They did. They said that the open front porch is included in the gross floor area, but we're going to give you a credit because we think that's a nice look for the city, a nice look for the neighborhoods of 250 square feet. That is easily distinguishable from a definition of gross floor area, which is not floor area ratio, and also for undefined terms, it doesn't include decks, it doesn't include any of those things within that definition. That was all I had, Mr. Capone.
All right, so we're ready to call the question. I'm going to ask for a motion. Now, I'd like to, for everyone's edification here, the motion, the applicant is entitled to a decision on his request. His request is for us to decide whether or not the building inspector has correctly or incorrectly interpreted the code. So I'd like the motion to be framed in a way that fits the question proposed by the applicant. And So that way you get a decision on the question you sought. Do you understand what I'm saying?
Yes.
Okay. So can I get a motion to that extent?
I will, doing to what you said in the positive, I will make a motion to affirm the appellant's I'm trying to think of the right word. Oh, you have one for me? Sorry. To reverse, okay, so you want it in the reverse decision. Okay, reversing the decision of the building inspector by holding that the deck and stairs submitted in this case don't constitute an exterior wall. So it's done in the positive. We're voting to either agree or not agree with the decision.
Right. So, so I'm going to ask for your vote to be either,
Okay.
Go through that one more time.
I move to reverse the decision of the building inspector by holding that the exterior deck and stairs as depicted on the site location plan submitted in this case do not constitute an exterior wall and therefore do not affect the gross floor area. Okay. I move to reverse the decision of the building inspector by holding that the exterior deck and stairs as depicted on the site location plan submitted in this case do not constitute an exterior wall and therefore do not affect the gross floor area. Done in the positive.
all right. So I'm going to ask for your votes to be, I affirm the decision of the building inspector, or I reverse the decision of the building inspector.
No.
No?
Wrong.
That's why
That's
you
right.
wanted it to be positive.
If I could add.
Go ahead.
I think, what we're struggling with is this idea that we need to come away with some kind of an affirmative decision on the part of the board. So a failed motion, particularly in the case of an appeal, doesn't constitute an affirmative act on the part of the Board of Adjustment, which has a duty to act tonight. So I think that this group is free to entertain a motion to uphold the decision of the building official or to reverse the decision.
Oh, we
of the-
can.
I believe that you can. Now, the concerns that we had about this, I think, relate more to the question of variances than
Okay,
appeals.
then I'll withdraw the motion.
So can I get a motion to either approve that, or the decision of the building inspector, or to reverse it?
Then I'll make a motion to agree with the decision of the building inspector in this particular case.
I'll second that.
Although, let's start with Barry Brandt. How do you vote?
I vote to uphold the building inspectors for the reason that I do believe that a railing is the exterior surface of a building.
Pappen?
I vote to affirm the decision of the building inspector. It is the code that we have to live by, and I think that's what we go with, what the code says.
Mr. Katz?
I'll affirm the decision. I won't go as far as what you said, though, but I do, I will affirm the decision, but I won't go as far that we go only by the code and nothing but by the code. But in this case, I would affirm your decision.
I'll affirm the decision. I think intent was there. I think a wall's clearly defined, and I do believe there's alternate solutions.
And I'll vote to approve and affirm the decision of the building inspector. I think that it meets the definition of exterior wall, and it is part of the structure. So we now move to the consideration of your variance request.
With
Mr. Molina, would you like to address the terms of the variance request?
I can, basically in items 4 and The issue with the variance is whether there is an exceptional hardship for this individual to operate without the deck, okay? And I believe the fire marshal and the building department has agreed on the option that they have available. The applicant has refused to comply because they indicate they have to relocate a door. There's nothing in our correspondence says that you have to relocate a door
Is the variance for the parking space?
for the parking space.
So I mean, it has nothing to do with whether they can or can't build the deck. If they build the deck, they're requesting a variance to not add the parking space.
That's correct. That's correct.
If
So
they don't build the
can-
deck, there's
so
no
They
issue.
can avoid having to provide a parking space by just enclosing the ground level entrance and using the second floor, the stairways on the second floor. It meets all the fire marshal requirements. It does not diminish safety in this property. So,
Questions for the building inspector?
And you would agree that the section 27035C locating within 700 feet would meet the code requirements so they could build the deck and get a parking space in one of the lots that surround that building?
That's correct.
Okay.
I can meet that.
Yeah, for the record, is there room on the lot that it's on to put a parking space?
No, here's what you have. The first floor require, I think, 7. I believe there's only space for 4. Previously, the mixed use was rental, which was a 2-bedroom unit. That required parking as well, so there appears to have been no compliance even with that parking requirement at that time. So they can't they can't find parking on that site.
On the site?
Right.
But they could, within 700 feet, if they owned
Yes, they
something
can.
else? Okay.
All right, any other questions for Mr. Molina? Mr. Hutt?
I'm not going to recite the whole history that got us here this evening, because obviously you heard that just a short while ago, so there's no need to repeat that. When Mr. Capone began the meeting, he talked about the quick check standard, which, as he indicated, is a balancing test set forth by the Supreme Court. And one of the things, actually, there's 4 factors that the board balances as part of its determination, and it needs to consider whether the request or the issue is a practical issue and not theoretical, and certainly, as you've heard, it is certainly not theoretical. It is very practical. Going through those 4 factors, I know Mr. Molina did in his report, but the nature of the zone in which the property lies, as was indicated at the outset, this is C1. Professional offices are permitted use in that district. And if you look at the stated purpose of that in your zoning code, the purpose of the C1 district is that the C1 district is designed to include those commercial areas wherein uses are not restricted as to the floor space size. So clearly this office, everybody's familiar with these offices. They've certainly been located there historically for a very long time. And the nature of that zone is professional offices in addition to other commercial uses. The second factor to consider is the character and use of the immediate vicinity. Again, as I said a moment ago, I'm sure everyone is familiar with the character of Rehoboth Avenue in general, and certainly the portion where the Lingo offices are located. You have commercial uses, you have professional offices, restaurants, retail areas, and the use as professional offices has been in existence for many years in that area. The third factor under the quick check standard is whether removal of the restriction on the applicant's property, and in this case, that restriction would be 1 parking place, would seriously affect the neighboring property and its uses. Of course, the removal of the restriction of 1 parking place for a walkway deck and a set of stairs would have no impact on a neighboring property or its uses. The use is the same. As I said at the outset of my comments, this doesn't allow for additional storage in the building. This doesn't allow for an additional employee. There is no practical impact of having this set of stairways that leads from a deck on that second floor doorway as the second means of egress from the building. The fourth factor is whether failure to remove the restriction results in an exceptional practical difficulty for the owner to make normal improvements in the character and use of their property. And as I said, I think it was a question we didn't answer earlier. In a moment, I'm going to ask Mr. Hammonds to address that question specifically. But the difficulty is that it is the various uses of the building. As it has been suggested that there are multiple entities that have the same name, but they are different, although some of them are related. And I'll let Mr. Hammonds speak to the difficulties that are created if you do the alternate method of walling in that first floor.
Sure.
Wait, before you do that, would you please swear on the Bible or affirm? You swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
So it's Nick Hammonds, and I'm a principal of Jack Lingo Asset Management, and we would occupy this second floor space. And as Mr. Hutt mentioned, there are, while related, different businesses at play here. And so the first floor business is a real estate sales office. And when the building was originally constructed, that door was in place, and that door is an access that they use to get to and from the place to transport materials out to their car, which is where the parking areas are, and it's something that they've always had as a part of their business. So it's an access that is used quite frequently by all of the occupants of that office, and it does create hardship if that access were to be eliminated. The other piece of this is, as they are related businesses, to the flip side, it is nice to be able to have access to the first floor office for my team, as well as for some of the folks that work on the first floor office to be able to walk up because there is affiliation and come to meetings in our office. So there are a number of difficulties it creates to close off that door.
Any questions?
If I may, as the quick check test or standard indicates, there's a balancing of the factors that occurs, and as has been mentioned several times, on balance, there is no change to the occupancy load of the building, to how it's used, with the granting of a variance for this newfound requirement of adding one parking place. There has been no argument from the city that something changes about the occupancy load. It's very familiar in whether it's commercial or residential settings for there to be an emergency egress set of stairs that comes down from a second floor to a street level. And so without any impact to neighboring property and their uses, the Jack Lingo Asset Management would ask that the variance be granted with respect to one additional parking place requirement.
Without any questions, are there any members of the audience who would like to address this particular variance request? Seeing none.
Jerry, I do have a question. So just for clarification, the interior steps coming down, you currently have access to the exterior as well as to the interior part of the office space.
That's correct.
Correct. And the fire marshal is saying if you want to make those offices upstairs, you have to seal off that door to the exterior,
Or create a second means of egress.
which is the deck.
Correct.
Okay, thank you.
I have a question.
Feel free to ask.
Does the building inspector agree with what they just said, that this does not create any additional occupancy for the building?
No, because I agree that the occupancy low with the square footage of, and what is detailed in the plan, is going to be 44, and I detailed that in my report.
So if that's true, and I'm just trying to understand this myself, and I understand that there was clearly, it's ambiguous and stuff like that, and we said we went with what your report said. But is anybody debating that this is creating harm to someone else if we were to grant the variance?
Well,
And that's what I'm just trying
you're
to
asking me, sir?
Well, or whoever else would be.
I refer back to the comprehensive development plan that encourages people to walk in, ride their bikes, or take other form of transportation other than vehicles. And as was previously indicated, under 7035, there is ample room on the adjacent lots that Lingo owned that could provide off-street parking for these.
Well, but by adding additional parking space does not help promote using public transportation. What I'm trying to get, and I believe in public transportation, and I don't park and all that kind of stuff, but I'm just trying to get at what is the harm if we grant this variance? They're not adding any additional occupiable space. They're adding a landing. But I'm just trying to get, in my mind, is there harm to somebody that I don't understand?
I will say that one, they moved up to the second floor. The deck is a structure that's enlarging, can be used for future use.
So Lou, can I, maybe I'll address it.
Okay.
And this probably comes as no surprise to anybody, but parking's a pretty big issue in this town, and the code requires the space. And so the harm is, it's one space here, but it could be 2 spaces later, it could be 5 spaces somewhere else, and that deteriorates the requirement for parking. So I would argue that you can't look at it as one space, but rather we're giving an exception to somebody that has a requirement within the city code to provide parking.
Dom, how many parking spaces are they now required to have?
They're, based on my calculation, they're required to have 7. Apparently, there are 4 for the first floor, 7.
And how much, do they have any room to park on site, or is this all designated areas?
They don't, on site, they don't have any room.
So where do these 7 cars park, or 4 cars?
They park right behind the building.
Is that designated area?
I suspect, I haven't gone that far to question whether that's designated for the occupants of that building or the entire complex.
And you're saying they're supposed to have 7 and they only have 4?
That's correct.
How did that happen?
I think that was before my time, Ms. Cole.
Okay, so I just want, for the record, to make sure I understand. They're supposed to have 7, they only have 4. If we grant this, we're compounding that problem even by 1 more.
That's correct.
Okay.
So then if they have designated area, and I'm assuming somewhere there on Christian Street, when they develop Christian Street, there goes their designated space because that building they erect needs that. So, like Linda said, we're compounding a problem on parking.
I would take a different approach to that. The parking requirement is not being increased or decreased because of some newfound area within the building where there's going to be employees located. And in a professional office, the question is what are the parking requirements? That building has only ever had the 4 parking places it's had. It may be pre-existing non-conforming. I don't know that, but that's a good guess. It may have nothing to do with the building inspector's office. But the addition of whether somebody walls off the first floor or adds a deck isn't going to change whether and how many people are using this office at all. And that's the balance that I was talking about a moment ago. And I think what Mr. Katz was referring to is that's why there is no harm, is because we're talking about a walkway, sort of boardwalk-looking walkway from that second floor door down to street level. How many parking places are there? It's not going to help or hurt whether or not there's more employees or somebody else again, or some storage area that's there, because you can't, it's not usable space. So again, I would argue that it's not compounding any problem. It's just the condition of the building as it exists today.
Would you agree, though, that the code doesn't distinguish between, I mean, the code, when it calls for parking, it doesn't distinguish between people and loads and things like that necessarily in this particular case, because it's adding on to the gross floor area?
With your decision, that's why we have to seek a variance. Again, the position is that it's not gross floor area in the first place, but with your decision, then certainly that's why we're here seeking the variance, is because the 400 square feet of deck requires one parking space under your parking code.
Is this a motion in the positive?
Do it, take a stab at it.
In my opinion, it doesn't have to be, it just has to be an affirmative, it has to be an affirmatively stated.
Well, I can affirmably state it in the negative.
So do you want to provide direction?
Okay, so we're asking for an affirmative motion in accordance with the request of the applicant to grant the variance, to relieve him of the obligation to provide a parking space. We're asking for an affirmative motion to relieve the, to grant him a variance, to relieve him of the obligation to provide a parking space. Does anybody want to make that motion?
I'll make that motion.
Okay, is there a second?
I'll second.
All right. All those in favor?
Wait, just,
Read the motion.
I want to make sure I know what we're voting on.
Yeah.
So if we vote in favor of the motion, we're granting the variance.
Correct.
If we vote against the motion, we're not granting the variance.
Correct.
Correct.
Okay?
Yep.
Everybody understand? All right, we're ready for a vote, and Barry, we're going to start down at your end.
Okay, I am going to vote in favor of the applicant. I do believe there is hardship. I hate giving up the parking, but I do believe there is hardship here with the fire marshal asking you to seal off that wall and understanding the nature of that location in Rehoboth Beach. It's not like the lot on the corner, which has parking. It's a very, very tight spot, so I'm going to approve the application.
Doug?
I vote against the motion because of the parking issues.
Lou?
I would vote in favor of the motion to grant the variance.
Please explain.
You have to give a reason.
Please explain.
Basically, on the lines of questions that I had, that I don't believe it creates harm to anybody to do that. I understand there are issues, but I would grant the variance.
Linda?
I vote no for the reason, I think what was described in wanting to close off the stairway was an inconvenience versus a hardship. I don't think it met the criteria for hardship. I think there are other parking spaces within an area, and I think the interior stairwell serves as an option, so I vote no.
I'm going to vote against the motion. I don't think that it's a hardship. I think that they're already shy of the number of required spaces, and I think that there's probably other parking available in the area. So I don't think it's a hardship, and the variance request is denied.
We take a 5-minute break.
We're going to take a 10-minute recess until the next hearing. We'll convene at 6:30, reconvene at 6:30.
Okay, we'll see how Rehoboth School does.
All right. We are back in session at 6:30. We're moving on to our second case, the Belle Hotel application. As I mentioned earlier this evening, the applicant here is seeking 7 variances. 6 of those requests are for area variances. The standards for those area variances are those found in the quick check case, which we discussed earlier and in the previous case. The 7th variance seeks relief from the requirements of Chapter 159, which addresses flood damage reduction. The differences between a typical area variance, like we had in the last case, and a flood zone variance, which we have in this case, are significant and deserve some background discussion at this point. In 1973, the city of Rehoboth Beach was accepted into the National Flood Insurance Program. And in 2014, the city code was amended so that the city could continue to meet the requirements of that program as found in Title 44 of the Code of Federal Regulation. That federal law contains its own procedures and its own set of standards for consideration of a floodplain variance. By its participation in the National Flood Insurance Program, the city is bound to follow those standards and procedures or risks being suspended from the program. The city has adopted those federal standards and procedures into the city code, and they are found in Chapter 159. And copies of that provision were outside on the table, and I hope many of you have had a chance to look at those. Chapter 159, Section 36, first requires the board to make findings of fact on all of the following factors. First, the danger that materials may be swept onto other lands as to the injury of others. Second, the danger to life and property due to flooding or erosion damage. Third, the susceptibility of the proposed development and its contents, if applicable, to flood damage and the effects of such damage on the individual owner. 4, the importance of the services provided by the proposed development to the community. 5, the availability of alternative locations for the proposed use which are not subject to or are subject to less flooding or erosion damage. 6, the necessity to the facility of a waterfront location where applicable, or if the facility is a functionally dependent use. 7, the compatibility of the proposed use with existing and anticipated development. 8, the relationship of the proposed use to the comprehensive plan for that area. 9, the safety of access to the property in times of flood for ordinary and emergency vehicles. 10, the expected heights, velocity, duration, rate of rise, and sediment transport of the floodwaters and the effective wave action, if applicable, expected at the site. And 11, the costs of providing government services during and after flood conditions, including maintenance and repair of public utilities and facilities such as sewer, gas, electrical, and water systems, and streets and bridges. So, ladies and gentlemen, in a variance of this type, the board has to make findings of fact as to each of those considerations. Significantly, the code first requires that the applicant shall specifically address each of these 11 considerations in his application. Now, if the 11 factors have been addressed by the applicant, and after the board has made findings of fact on those 11 factors just mentioned, the board may grant a variance request if all the following conditions are met. And I say all the following conditions. This is like, if you've ever been in court, this is like jury instructions, but I think it's important that you hear these things. So please pay attention. The applicant must have made a showing of good and sufficient cause. A good and sufficient cause is one that deals with the physical characteristics of the property and cannot be based on the character of the planned construction or substantial improvement, the personal characteristics of the owner or inhabitants, or local provisions that regulate standards other than health and public safety standards. That's the first condition. Second, the board needs to find that failure to grant the variance would result in exceptional hardship due to the physical characteristics of the property. Increased cost or inconvenience of meeting the requirements of these regulations does not constitute an exceptional hardship. And the board needs to find that the granting of the variance will not result in increased flood heights beyond that which is allowed in these regulations. And the board would also need to find that the granting of a variance will not result in additional threats to public safety, extraordinary public expense, nuisances, fraud or victimization of the public, or conflict with existing local laws. And the board would need to determine that the structure is protected by methods to minimize flood damage. And the board needs to determine that the variance is the minimum necessary considering the flood hazard to afford relief. So you can see that the criteria that we have to use in this type of variance is dramatically different, more far-ranging than the quick check criteria which we had in the previous case. And it's also worth noting here in that Section 159-7 of the City Code states that all provisions of Chapter 159 are to be liberally construed in favor of the city. So, those are the ground rules which are in place for consideration of the variance under Chapter 159, the floodplain variance, which is one of the 7 that's being sought tonight. With that being said, and I know it was a mouthful, but it's the tools we have to use here tonight. So you've all heard what they are. Now we can begin the hearing. And I'd like to start by having the parties introduce themselves.
My name is Hal Dukes from the law firm of Tunnel and Razor. My clients are John Papajohn and the Papajohn family. John Papajohn sits to my right. We also have Ben Seidel, who will be one of the witnesses, and Peter Follett, who had designed the property, and finally Susan Frederick, who will give us consulting on the variances and the applications of the ordinances.
Okay. First variance request that the board would like to address is your request for relief under Chapter 159, the Flood Damage Reduction Ordinance. Now, I must tell you at the outset that I have concerns that the application you submitted does not address all 11 factors which federal law and the city code require to be included in the application. Between the surveys, the plans, and the other written materials, there was a lot to digest. So the possibility exists that I may have missed some things or did not fully understand them. I'm not an architect or an engineer. So if you take issue with my concerns about the completeness of your application, I'm ready to be enlightened. I'm hard to embarrass because I'm a criminal defense attorney, so. But if you would like to address whether or not I would like you to address whether or not your application addresses those 11 considerations which I mentioned previously.
Well, our engineer will be able to discuss that.
Excuse me, sir?
Our engineer will be able to discuss that with you when he makes his presentation. But I think we do have adequate information provided.
Well, I'm not prepared to get into the presentation. I would like to address my concerns that the application is incomplete. And I'm concerned that if we feel the application is incomplete, then I have concerns about going forward on an incomplete application. So the first order of business, as far as I'm concerned, is I'd like to address the completeness of the application. Now, we can go through them one by one, but we have 11 factors that by law, were required to be included in the application.
You didn't affirm them, they have to swear in too.
Excuse me? They're going to swear.
Peter, you want to talk to those, or do you want me to do it?
If you know what, maybe I threw a curveball. If you would like a recess for 5 or 10 minutes to discuss the way I propose to run the meeting, I'll be happy to give that to you, okay?
Well, I don't want to tie up people on something like this. We have included in our application the FEMA pamphlet dated July 2013, and with that is a discussion of flood proofing and of non-residential buildings, and we think we've met all the criteria in that pamphlet.
I got to tell you, I disagree with it. It's a pamphlet. That states what this is the pamphlet that deals with flood.
It's the FEMA technical
Right.
brochure that they put out that you use to determine these things. But before we get there, it's my understanding that
Would you speak?
Susan Frederick. It's my understanding there was a meeting with the architect and with Mr. Molina where they discussed this issue, and it may be a non-issue altogether. As far as we know, we have different heights around the whole building. The boardwalk's a little higher than Rehoboth Avenue. Our goal is to meet all of these, and our only problem is that we are higher than we need to be at the boardwalk, and we are within inches, which may be solvable as we go down Rehoboth Avenue. I mean, inches, because of the height of the sidewalk. We're trying to make this so there are no ramps to get into the building, because that creates a problem on Rehoboth Avenue. So I think that this may be a non-issue at this time, and besides that, we can work on resolution for that.
Well,
And that was my understanding from the discussion between Mr. Molina and Mr. Flott.
Well, I'm going to tell you something else. My understanding is that you needed to address those 11, and I believe that the city needed to address the 11 criteria as well. But an application is before us for a variance from the Chapter 159, and my reading of that is that you were required to address all 11 of those considerations. And the fact that there might be a minimal difference here is one of the factors, but it's only one of 11. So
I think that at this point, I believe that we had answered all of these in in the information that I provided in what we were seeking. I don't have an actual elevation of the floor around the building 100%, so perhaps it is premature then to review this at this time. But only that request.
Perhaps it is premature to do this at this time.
Because, well, my understanding was that when they discussed it, it seemed that it was solvable. And this was after this was submitted.
So are you withdrawing that variance?
Yeah, you know what? Are you withdrawing do you want a continuance?
On that particular?
No. Do you want a continuance on your hearing?
On the whole thing?
Yeah, because this is the cornerstone. To me, it's like a Jenga puzzle with the blocks constructed up, and we're working on the bottom one right now.
Well, I tend to disagree with that because the cornerstone for me is parking. Because without some kind of review of that, there's no way for the project to proceed. And that was what, I would like to proceed with the other variances and review them. And if this one gets tabled, I have no problem with that. But I don't want to withhold the whole project based on that one. We can go through the rest of the code and leave Chapter 159 at this time if that's a problem.
I think it's a problem to me. I think that these are all related, and
I
I'm concerned that one of the things I read was that if you don't, this affects the height of the building from 42 to 43 feet. And I,
No, it doesn't.
No,
It
it does
doesn't.
not.
there's a dispute about that?
No, there isn't.
No.
It adds,
There's no
it adds a
dispute.
foot.
I don't know everyone's name that's,
No, it doesn't. It's
I
not
know
called.
Miss Frederick, but I'm not sure the gentleman that's.
Peter Follett, architect.
We,
Don?
Don Molina. We, based on the, on the property, based on the property survey, I did make a conclusion that the average was 11.8 to 12, and 1 foot is still a requirement under the definition of gross floor area. Now, the alternative is that they're proposing is to,
The alternative is to what?
the alternative is that they're proposing to waterproof the building and not increase the building, elevate the building above the base flood elevation.
Well, the alternative is that they waterproof the building, but the fact of the matter is that it's still, they still require a variance, and they have to, how they waterproof the building is one of the considerations of the 11 considerations. There have to be 11 considerations discussed. There weren't. Now, you're telling me that you want to withdraw your request for a variance under the floodplain, under Chapter 159. Is that what I'm hearing?
No, we're not saying that.
What am I hearing?
What we're asking for is an opportunity to go through the variances one at a time. If you have a question on the variance for flood insurance, we could come back at another time. We could, to meet your criteria, but we think we've met the criteria.
But-
If you say we haven't met the criteria, then you're in charge of this meeting. You can go ahead and say, well, do it another time, or I don't have sufficient information.
Well, we couldn't act on the height.
Well, let me just explain a couple issues, okay? The design elevation is 12, okay? Elevation 12, that's the FEMA design elevation. I'm sorry. The design elevation is 12, okay? That's the FEMA design elevation. We're required to have a 1-foot freeboard above the 12 elevation, okay? That freeboard is to the underside of the slab of the building, okay? The slab of the building will be 8 inches, okay? So that means the top of the slab of the building needs to be at 13.67, okay? At the corner of Rehoboth Avenue and the boardwalk at Candy Kitchen, it happens to be 13.67, okay? So that corner of the building also matches the sidewalk, right? If we wanted this to go away completely, we could design the whole building at 13.67, running the next 200 feet down, plus or minus down Rehoboth Avenue, okay? But what happens is Rehoboth Avenue dips slightly to 12.67, okay? Which means that in order for a handicapped person to come in the building, there would need to be a small handicap ramp, okay? That's the nature of the variance request, okay, is for us to allow that portion of the building to be at 12.67 with FEMA-approved floodproofing, and the details of which we can explain. Now, let me go backwards before you go forwards, and that is that we are proposing to measure the building from the lowest point of the sidewalk, not the highest point of the sidewalk. So the 42-foot height building, which is required, will be from the 12.67 elevation, not the 13.67 elevation. So we're not asking for a building height variance at all in regards to that, okay? And so in this matter,
Mr. Fleck,
Yes.
you were on a roll. I didn't want to interrupt you. But we do have a procedure here where we swear our witnesses. And we'd like to ask you to indicate both that your testimony, and I think Mr. Capone will administer the oath, was sworn testimony when you gave it, and what you have left to say will also be true and correct.
correct, do you want to do Susan? too?
Do you affirm that the testimony you've given and which you're about to give is the truth, the whole truth, and nothing but the truth?
Yes. So, that's the nature of the conversation here in regards to the floodplain.
But you're still seeking a floodplain variance,
Correct.
correct? And as such, clearly, when you look at the difference between the quick check criteria and these criteria, there's a reason for that. And And the city, we're obligated to follow the federal rules as they've been imposed on the city, and you're bound to follow those as well. And the way I read the law, you have to advise us, you have to respond to all 11 of these criteria. And I understand that you're saying this is de minimis. You're just looking at, it's not that big a difference. It doesn't matter. That's one of 11 factors. So you've addressed one, but you need to have addressed the other 10 in your application.
We will in this presentation.
Excuse me?
We will in this presentation.
Now, the presentation, here's the concern. I believe that you needed to address this in the application, and you need to address it tonight. The public needed to be aware of all 11 issues and how you were addressing them. Your application does not do that. This report doesn't do it either. But the fact of the matter is, we've got this code here, and we've got this is the tool that we have to deal with, and the public needs to be aware that the 11 issues were addressed, and you need to address them here tonight and respond to our questions. Now, since you haven't, in my opinion, submitted a completed application, as I said, I'm willing to be, if you want to show me your application where I missed a few things, that's fine, we can do that. But I don't want to go forward until I know that your application was complete, or if it was incomplete. And then I think we have then I think we have a problem if it was incomplete. So that's where I am.
We're asking to reply and respond to Mr. Molina's statements. When we made the presentation for this project, Mr. Molina said you have to do the following things. He's been extremely helpful in this transaction. We've worked over a year with Mr. Molina, with our engineers and our architects. And this was the 7 items that we were asked to present to you tonight.
There were 7 items that you're presenting, but one of those particular items is different than the other 6.
Well, we had, that's true, but we had to respond to what he requested us to do, and that's what we've done.
Yeah, well, what I believe is you needed to respond to the requirements of Section 159-36 and the Code of Federal Regulations. So we're back at the point. I am asking you to tell me where in your application you've dealt with all 11 of these issues. And if not, if you'd like to continue the hearing, I'm willing to ask for a motion to that effect. But if you're going to make a variance request under Chapter 159, you're going to have to address all 11 factors.
Well, let me suggest this. We have 6 other factors, all that are important to this transaction. We've said that we could design the building. Of course, it depends on measurement, and it depends on the variance, of course, to meet the criteria. But we could do this at another hearing time.
Well, let me ask
Because
you.
if we don't have the parking, then the flood doesn't mean a thing.
And if I'm going to suggest this to you. If you want the parking, you need to address, I think it would be helpful to you. I mean, we haven't heard any testimony, but I think it would be in your best interest to address the floodplain issues before you address putting 110 parking places underground. That seems like it would make sense to me. So,
At the first hearing we
Are
had,
you Mr.
Papa John, yes.
Mr. Papa John, do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Go ahead, Mr. Papa John.
John, at our first hearing, one of the statements, I believe, you tell me if I'm mischaracterizing it, is that parking may be, or is, I don't remember exactly, included in the floor area ratio. In other words, we can put in stores. It's the only thing I knew when we first started this years ago, that we can build lot line to lot line for stores. And then once you go above that, 3 stories, the FAR kicks in with a 50% ratio. You cannot have apartments, motels, whatever, above the first story. And yet minimum is, and maximum allowed is 50% of your lot. Now, if parking is off the table, that you're going to include all of the underground parking and anything we have above ground to take care of handicap and whatever. If that's included in the FAR, I told the planning commission and anybody that could hear me, let's just not waste everybody's time, including the city and ours and all the funds that we've expended, et cetera. The parking is crucial. If we can't have it, let's just forget it and put in a minimum amount of investment and just put in a small place.
So I understand what you're saying. But I want you to understand what I'm saying. I think the possibility exists that you and whoever else you were talking with from the city were discussing certain issues, but that this particular section, which I've brought up here tonight, was not mentioned. Am I right about that?
Well, I heard some talk about it, but I said I didn't quite follow what the requirements were, so I said, I'll leave it up to the experts. You know, it's like going to a doctor. You don't second guess them, you say, well, what do you think?
I'm going to tell you this. I think that this may be the first time that an application for relief like this has ever been made to the city. Certainly, it's my first experience with it. But having said that, it's pretty clear to me what needed to be done. And for whatever reason, I don't believe your application is complete. Now, I don't want to join in the conversation with you and other parties that may have missed the boat, because I think I'm right about this. So I'd like to correct the course of this and say, if we're going to consider this application, let's get it right. Let's get your application right and address these 11 topics. Now, if they aren't addressed, and the more I hear your folks talk, I don't think you addressed all 11 in your application. If they weren't addressed, let's give you the opportunity to, if you want to go forward, to address all 11 and come back. I have no problem with that. And I would vote to give you a continuance and let you come back and hear it on the full record. But I don't think your application is complete as required by our statute and by federal law.
Well, can you hear all of our requests except for that? And we have a continuance just for that
Now-
in order to come up with hopefully what you might need.
Do you really think that you're going to get a full hearing on your parking question if we haven't resolved the floodplain issue? It just doesn't make sense to me. I'm the chairman of the board. So I'm.
You can build parking in the flood.
Excuse me?
You can build parking in the flood.
With all due respect, sir.
Yes, sir.
Yes, we understand that, and we obviously can read and see what you're saying, but they are separate issues. We do not intend to build an underground garage that will fill with water. It's not the intention. We do plan on building a building that meets all the FEMA requirements and all the floodplain. Now, you're right. We may not have addressed all 11 of those points in the application for this particular issue. But on all the other issues, we have spent a lot of time. We've worked hand in hand with the planning department and the building department, and we have you've been great to work with, and we are ready to speak to the others. But if you feel it is not in the best interest of then we probably should ask for a continuance. I mean,
I think you got my drift.
You can't continue just the floodplain part and go through the rest.
I think that you'd be making a mistake.
Really?
Yeah, I do.
Why?
Now, is that,
I think I've stated my rationale enough.
Well, frankly, I don't follow the rationale, but I mean, if that's the way you feel, you don't want to go ahead. I'd like to go ahead on all the others, which are fairly clear and clean, I believe. Because if we keep going through continuances, we've been at this for quite many, many months, we're never going to get this place built.
I'm throwing the option out there for you. It's your decision. If you want a continuance, we'll consider it. And I'll even tell you that I would probably I'll vote in favor of it. But if you want to go forward, we're going to go forward.
All right, can we just have a slow little quick recess of 5 or 10 minutes?
Yes, as I told you, you could.
When Ann walks, everybody stops.
They ran away?
I said, when you walk, everybody stops.
Well,
I'm impressed.
Continue it, you want to continue it.
All of it. We're gonna have to do, yeah.
We're back in session.
Okay, we've had a meeting, and on advice of our counsel, Jerry Capone, we've decided to ask for a continuance.
Decided what? Decided.
To request a continuance, and we'd like to set the meeting up as soon as Mr. Capone is ready and is available.
You know, obviously, I'm not acting as your counsel. I appreciate the joke, but the decision is yours. If you want to go forward tonight, we were prepared to go forward, but you've made a decision. Now, with that decision, I think it requires a motion of the board to grant you a continuance. Is there a motion that this case be continued?
I'll make a motion that we continue the case with the caveat that all of these things that we're talking about, the height, whether it's 13.6 or 6 inches or whatever, gets resolved before it comes back here again so that we're not debating those same things.
Okay, is there a second?
Second.
Sam Cooper standing up. Do you wish to speak? I do. Would you come up to the microphone and swear under oath, please? Swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do. I would just like to say that I think that there's a big misunderstanding here. I think from what I can hear and what I've seen in writing, there's been a big misinterpretation because clearly under the code, the lowest floor must be below the, what was it, below the elevation. And the definition of lowest floor is the lowest area, enclosed area, including basement of a structure. And also within the residential, non-residential structures of
Are
the
you
section.
speaking to the, Mayor Cooper, are you speaking to the motion that we just had?
No, I'm
No,
not. I'm
okay.
speaking
Then-
that I think people are wasting their time to come back with what they were going to
Okay,
present
well,
tonight.
the motion on the floor is to continue the hearing. We're
Okay.
about to take a vote on that, please.
I'll be back.
All those in favor of the motion signify by saying aye.
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 Any opposed? No. Your continuance is granted. Okay, that concludes the hearing tonight.
When would we come back?
Do we have any kind of tentative date?
I would say as soon as
Okay.
the town tells
September?
us that you've
I-
met those requirements.